Good morning, good morning, good morning. I hope everyone's doing great. How are you all doing? All right. So I'm going to wait for people to join me because today is just going to be a Q&A. So please type in your most pressing questions into the comment. I really only have less than 30 minutes because I have a consultation at 10:30, so I would need to leave. But I wanted to talk about a couple of questions I get all the time, and I invite you to put your own questions in the um, in the comment section. Good morning, everyone. Good morning, Gen 16. Good morning. How are you? I'm great. I'm great. Thank you. So my name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami law firm. Our law firm is here in New Jersey, but we serve clients in all 50 states. And the reason for that is because immigration is federal law. And so you don't need to be able to come to our office or be able to see me in person for us to be able to assist you. We do our strategy consultations on Zoom, on Instagram. Sorry, we do it on Zoom and in on by phone and in person. So, good morning, everyone. Thank you for joining me. So, if you have an immigration issue, feel free to give us a call. The number to call, and this is the only number you should call, as long as you're not a client. When you become a client, we give you another number that takes you directly to the team you're working with. But everyone else, please call 973-993-1900. And the reason I'm telling you this is because there are a lot of people trying to scam intending immigrants, pretending to be me. They're trying to get money from you in your messages or whatever. We never ask you for money. You pay a consultation fee and you do a consultation. And when we decide what your case structure is going to be like, we discuss even the fees with you. So don't ever talk to somebody on your DM and they're telling you they're going to get you a green card and charging you money or charging you money for a consultation. So the best way to get a consultation with me or any of the lawyers in the firm is to call us at 973-993-1900 or go to our website and book a consultation. And if the time is, it's really, if you're looking for closer dates, then pay for the consultation, put a date, and then contact the law firm to see if you can get something earlier. So good morning, everyone. Good morning. So I want to get started. So I just want to talk about a question or an issue that has raised itself recently, and I want to make sure that we address it for you guys in case somebody out there has this issue. I had a colleague who, not an immigration lawyer, but had filed a petition for her husband, and her husband has two kids. One is, I believe, 19, and the other is maybe, I don't know, 15. And she filed a petition for her husband to get a green card. And the plan is, this is a plan she explained to me, that she and her husband would wait for him to get his green card and then he could file for the other kids. And I told her right then and then that that's not a good idea, and I'll explain why. So the thing is, a green card holder filing for their child, there's certain restrictions. First of all, if you're a green card holder, the beneficiary of your petition must be in legal status as of the time you file the petition for them, must be in legal status for them to be able to adjust their status and get a green card within the United States. If they're not in legal status, they will have to go leave the United States. And so for a child who's 19, the chances of her being able to adjust her status within the United States is really zero because, number one, she's already out of status, right? She's accrued unlawful presence. Number two, the priority date for a green card holder filing for their child is not current, which means they're going to wait. And if they wait and that child is over 21, then that now puts them in a different category, which the wait time is about 3-4 years. So I did talk to her and I asked, well, was this child under the age of 18 when you married her father? And she said, yes. So I said, so she is your stepchild according to immigration. So if she's your stepchild, go ahead right this second and file another petition for her. And while you're at that, why don't you go ahead and file for the second one? Because it's just quicker, easier, and cleaner. And the reason is because immediate relatives who are a U.S. citizen filing for their spouse, a U.S. citizen filing for their children under the age of 21, and a U.S. citizen who's over the age of 21 filing for their parents. These three categories are called immediate relatives. There's no waiting period. And it doesn't matter if they're not in legal status, as long as they had a legal entry, which means they came in with a visa. The visa might have expired, it doesn't matter. All right. So it's important to know this little fine details, because if she hadn't spoken to me about that, she would have been waiting for her husband to get his green card, then file the petition, only to find out that, oh my goodness, this is a problem for this young child, because now she has to leave the country. She now has to file a waiver. It just gets complicated. So that's why I tell people before, even if you're going to file a petition yourself, it's important to talk to a lawyer, not a notarian, not a case preparer, because the case preparer can fill out the forms, but they don't know the details, the laws behind those forms. All right. So I'm going to take some questions, and I'll come back to answer another FAQ, but I want to just take some questions from you guys right now. All right. Good morning, Temple. All right. Let's see if I have questions on. Flight Stew says, how long for 10 years green card? We have first one. So Flight Stews, your question is not really clear, but I'm suspecting you mean you have a temporary green card, which is a 2-year green card, which clearly tells me that you got married to a U.S. citizen and the marriage was less than 2 years when your green card was approved. So now you have a temporary green card. So within 90 days of the expiration of that green card, you must file the Form I-751 to remove the conditions. And that's when you will get your 10-year green card. Now, the Form I-751 is taking a long time to be processed. As a matter of fact, when you file the Form I-751, they will give you an extension letter, which extends your green card for another 48 months, which is 4 years. Really, this is just to give them time to make a decision on your case. What we are seeing is it's not quite taking 4 years for them to make a decision, but it's taken a couple of years. Now, typically what we do for our clients is, if they're still in marital union, still married and living with their spouse, by the 3rd year of having their green card, we encourage them to file a naturalization, which actually helps to push the process of the I-751, because USCIS must make a decision on the I-751 before they naturalize, they complete the naturalization. All right. All right, so greetings to everyone. Greetings to Owais, greetings to Lufemi, and greetings to JP. So let's see if I can get another question on, because I'm seeing questions on Instagram. So Usman says, what does one need to file for work permit after marriage? So Usman, I'm assuming if you're married to a U.S. citizen and you had a legal entry, typically you would file the adjustment of status, which is the I-485, and then you also have to file the Form I-765. The Form I-765 is the work permit form, and the filing fee for that currently is $260. There's also a filing fee for the Form I-485, which is $1,440. Okay. If you want a travel permit, you would have to file that separately. So son of B4 says, am I considered legal on a pending asylum? Son of, this is a fantastic question, and I'm happy to answer it. So son of, you're not legal on a pending asylum. You have authorized stay. And I want to really explain this, because this is really confusing for a lot of people. So they come in and they file asylum, and of course they're waiting for the asylum papers to be processed. They get a work permit, they're working, and then somebody wants to file maybe an employment petition for them. Now, as you guys know, on an employment visa, you have to be in legal status, and you must never have been out of legal status for you to be able to adjust your status in the United States. So even if you have a pending asylum, you're not in legal status as long as you've overstayed the 6 months that the I-94 tells you that you're allowed to stay. So Now, if you came through the border, you're not in legal status, period, because you were never given authorized to stay here. So now, if you file your asylum before the 6th month, that means you have no unlawful presence. And that is really helpful because what that does is if, say, you got a job offer from an employer, you'll be able to leave the country, consular process, and come back for your green card without having to file a waiver because you have no unlawful presence. However, if you stayed over 6 months, or if you filed your asylum after 6 months, you have now begun to accumulate unlawful presence, which means that you're going to need a waiver, which you can only get if you have a U.S. citizen or green card holder parent or spouse who you can show would suffer extreme hardship if you are not allowed to come back. So yes, the answer is a pending asylum is not a legal status. It's an authorized stay. Those are two different things. You can adjust your status on a legal. You can adjust your status to get a green card on a legal status, but not on authorized stay. All right. So thank you for that question. I think that's really important because I've had a couple of people reach out to me about that. So Idira Samuel says, I'm currently residing in Canada, but on an international student visa. I also have a U.S. visiting visa. How do I get a church worker job in U.S. and get a green card? So Idira Samuel, it's not really how do you get a church worker job. The church, first of all, has to be properly designated as a non-for-profit, right? That's number one. You have to have been a member of that church wherever you are for the 2 years preceding the filing, right? So churches have branches or affiliations. You have to have been a member, and to work as a church worker, you have to be performing a certain role, either as a minister or worker, and a minister or worker. And there's another category I forget, but it's not so much how do I get a church worker job as much as do you qualify to file for an R1, and there's certain requirements for filing an R1. A lot of people don't meet the requirement of having been a member of the church for 2 years, or that the church is not a properly designated non-for-profit, okay? So Ademi says, my removal condition of green card has been pending for 4 years. What would you do? That's a long time, Ademi. As always, when your case is pending for a long time, right, and you want to move it, you can file a writ of mandamus. So what I would suggest to you, first of all, is to go the conservative route, not because you're afraid of anything. It's just more to show the court when you file that you've done everything else to get USCIS to move your case and nothing has happened, and therefore you're filing with the court. So you first of all reach out to USCIS and ask them what's going on. It's taking 4 years since I filed my removal of conditions. And then you get congressional assistance. Call your congressman, see if they can assist you. And if they don't, or they do, and it's not, nothing happens, then go ahead and file a writ of mandamus. We do a lot of writs of mandamus, and I'm telling you that within a week, sometimes as little as 2 days, we get a response. So it's not that the writ of mandamus is going to get you approved, but the writ of mandamus is basically saying that USCIS needs to go and review this case and make a decision on your case, and that's what the court compels them to do. Okay. So if you need help or you need assistance, give us a call. Let's review your case and see what's going on. Sometimes a client I tell, maybe you don't want to rush this case. Okay, let it take its time. All right. All right. So still looking on Instagram because I'm not seeing questions anywhere else. Okay, actually, there's a question here on YouTube. Keep on Shining says, is it possible to bring siblings that are already adults and married? Of course. Keep on Shining. If you're a U.S. citizen, you can file for your siblings, and your siblings that are adult and married, their spouses and their children under the age of 21, hopefully they don't age out, will be derivatives of your petition. So yes, definitely you can do that. Shalene, hello. Olufemi says, how do you discuss with me privately? Olufemi, you have to call my firm and schedule a strategy consultation with us, 973-993-1900. And depending on the issue you have, you will be assigned to the attorney who can best assist you, okay? So Shireen says, can an adult child file for parent on a 10-year bar? Parent went back to home country, parent have to wait out the bar. Thanks. So, Shirlene, it depends on what the basis for that bar is. But typically, children are not qualifying relatives for a waiver, right? So depending on what the reason for the bar is, they probably have to wait it out. So you should call our office. Let's listen to what's going on and be able to advise you on what to do. All right. All right. So let's go to TikTok. If anyone knows how to make the script larger on TikTok, let me know, because honestly, I struggle with this trying to read the font. The font is so tiny. All right. So on TikTok, someone says, will USCIS find out you claim to be a US citizen on an I-9 form as a minor? I don't know if they can find out. Honestly, I don't know. They may not, if they're looking and if they have reason to suspect and their records still, because a lot of times there are no records anymore of I-9s a long time ago, but that is a permanent bar. So yeah. So somebody else also asks, is TPS a status? So TPS is an authorized state, it's not a legal status either. So can you change your status when you win a DV lottery? It depends. We need to know what your immigration history is, whether you have inadmissibilities. So just because you win the DV lottery doesn't mean that you can adjust your status. If you're inadmissible, you're not going to be able to. So, all right. So Gakinia says, any updates on DACA? Unfortunately, no updates on DACA. All right. We're still waiting. And Ismail says, I got my VAWA approved. Congratulations. And they took my fingerprints for the green card. What's the next step? So Ismail, well, first of all, congratulations. I'm happy for you that you got your VAWA approved. So the next step is, well, they could call you for an interview for your I-485 adjustment of status if you did file one, or they could just send you your green card because they didn't need to interview you, all right? And sometimes they might send you an RFE for medicals if you didn't submit a medical at the same time, or RFE for I-864W showing that you're not required to fill the affidavit of support. All right. So let's go back to Olufemi says the contact was fast. I know I talk really fast, especially in the morning when I'm still digesting the caffeine. So the phone number is 973-993-1900. 973-993-1900. All right, Hiram says, do I need to send copies of each month's bills and statements for 2 years for I-751 evidence filing? So Hiram, it really depends, because an I-751 is, there's no rule that you have to send, copies of, bill for every month for 2 years, but it depends on the strength of your other evidence. So we basically look at everything and decide which, the strongest evidence to submit. There's nothing wrong with doing that if you want to, but make sure it's bills that really help your case, because if you have monthly bills and bank statements that don't show that you and your spouse are jointly using your account, that is really a waste of paper because it really doesn't help you. It actually hurts you if USCIS is looking at 2 years of monthly statements and nothing there shows that you people are, financially commingled. All right. So, inspired by Fola says, is divorce decree that was done virtually in Nigeria accepted by USCIS? You have been a resident of Canada for 3 years and your fiance wants to do a K1 petition for you, and you just got your divorce decree from Nigeria. So, inspired by Fola, I'm sure you know this because I say this all the time. Nigeria has a really big problem with divorce decrees as far as USCIS is concerned. USCIS finds that a lot of Nigerian divorce decrees, are not properly done, and they deny cases based on that, rightfully so, because if your divorce was not properly done, then your marriage to a US citizen is not proper. In addition, if your divorce is not properly done, in your case, your K1 cannot proceed because you have to be divorced, showing that you're single and in a position to get married again. So this divorce thing is an issue, and it's not something I can discuss here on a live that I'm going to be leaving in another minute. So I'm going to advise you to make sure that divorce was properly done. You should get a lawyer you trust in Nigeria to authenticate it. If you wish, you can call my office and let's basically review what you have. And if we have any doubt, we actually ask a lawyer to authenticate it. Sometimes you don't need a divorce decree if it's a traditional marriage. Okay. All right, guys. I gotta go. So I will be in. I'll do my next live again, hopefully next week. So I hope you guys all have a great weekend. I gotta run for my consultation. Take care. Bye bye.